Welcome everybody to our Leaders in Housing Counseling call. We're already in the middle of May, can you believe it? I know there's a lot happening in your world and there's a lot happening in our world as well. So we're going to touch on some of that, but I think the main focus of this call will be around a useful set of tools for helping people where a family member may have died to keep the house in the family, and an important element in our work. So let's let's dive in. Let's do a quick review on what the agenda is, and so we can get to business here. So first, we're going to do a quick rundown from Tika on the legislative updates of what we've got happening in Congress, and especially our initiative to raise the housing counseling funding substantially this year, getting some real traction on it, so very useful to all of us. And we had a breakthrough on FHA's rules around forbearance and how they were being treated in the field. A number of you brought up these issues on our last call, and boy, we got a very quick response. Ellie's going to give you the piece to all this, but just want to wave the flag that it's really valuable for you to elevate the problems that you're seeing in the field, that you're having with servicers, with lenders, all that sort of thing, because we are able to elevate these issues. And we had an impressive response from FHA, but Ellie will go through all the details. I'm going to jump on a few highlights of things that are happening in our world. The Black Homeownership Collaborative, we're doing a little bit of outreach for you all to participate. We had a meeting through the collaborative with Secretary Fudge, which I thought was really, really valuable, and I feel like worth sharing kind of a little bit of the high points and enthusiasm. And then just an initiative that we've talked about on the call before about dealing with cash buyers and with homeowners and first-time homeowners, especially being at a disadvantage in the marketplace, and what can we do about it? So this is a recruitment to get more thoughts and experience about all this. And then we also had a meeting with David Berenbaum from the Office of the Secretary of the Office of Housing Counseling, and David, of course, was on our call a number of weeks ago, but is the new director there, and just trying to deal with a lot of the mechanical issues that your agencies have in negotiating with HUD or having contracts with HUD. This was a terrific meeting, and we think of high value, and Ellie will give you a rundown from that. But we're going to spend most of the call on this whole idea about protecting generational wealth. I mean, it came to us partly because we were, as you know, been really involved with how do we increase and maintain Black home ownership. This is a component of all that, and we raised some ideas that would be legislative ideas about how to do this, and a number of the leading lawyers in our advocacy field pointed out that there's already tools to do this, and what we want to do is give you a really deep background on this and how you can use it in your programs, and we can use this to help people keep homes in their family in Black, brown, white, Asian, all the communities we work in, but that it's a way of maintaining home ownership in an environment where this is increasingly difficult. And Ellie has pointed out, I guess also that this applies not only to if somebody dies, but also in cases of divorce. So we'll learn all about this. We'll do a quick plug on NHRC membership. Really appreciate all the support we're seeing out there. And let's get started here. So looks like we have a very good turnout already on the call, so that's good. So Latika, what's happening?
Good afternoon, everyone, and thank you so much for being here today. One big initiative that we're pushing, great thanks to all who have signed on to our letter. Right now, we have over 300 signatures, so that's amazing. Woo! Give it up for us and for you all, because this initiative is important for all of us to be provided with the resources that we need in order to help homeowners, renters, seniors, people struggling with homelessness, etc., helping them secure affordable, quality housing. So right now we have a sign-on letter going around. This is our final call, actually, to get more signatures. Right now we're lacking in some states, specifically Wisconsin. So if you're on the line and you're a housing counseling organization in Wisconsin, we would greatly appreciate your signature. And if anyone else who has not signed on to the letter and would like to join our collective efforts in gaining $100 million in housing counseling for next year, we encourage you to sign on to our letter as well. And great news, some offices are still accepting appropriations request letters. So if you could reach out to your Senate members and your House representatives asking for this $100 million request, the more voice that they hear from, the important voice that you all have out in the community, their constituents, will be greatly appreciated. In all of our efforts collectively, we hope that we will be able to obtain $100 million next year. I will include a link to the sign-on letter in the chat. If you would like contact information for your senators in your state, I can send that to you also. Thank you.
Excellent. So we're really on the line here, and anything you could do to add a few signatures, we're really trying to get this into the House and Senate next week, early next week, hopefully. Okay, so Ellie, can you fill us in on this FHA guidance on forbearance?
Sure. Hi, everybody. So the FHA guidance on forbearance, what happened was we had a call with Mark McCardle at CFPB a couple of weeks ago, and he was talking about the proposed changes to the mortgage servicing rule. And you all made sure to let him know about some issues that you were seeing. And one that came up that many of you talked about was that you were hearing servicers tell homeowners that they could not be considered for any kind of loss mitigation until they completely and fully exited forbearance. So Mark took that. He reached out to a contact at HUD. I reached out to Steve Sharp at the National Consumer Law Center, who is our FHA expert. And it was pretty clear right away that that's not true. And it's incorrect for servicers to be telling their homeowners that they have to exit forbearance before they can be considered. So when I found out that it was Will Innes with HUD that was the person Mark McCardle had been reaching out to, I connected with him directly to say, what do we do for housing counselors? What can they say? And within a couple of days after getting stories from us and getting stories from Steve Sharp at NCLC, then they issued that notice that came up in an email, and we sent out to everybody. In the next slide, I'll just quickly go to it because I have it right here. So the slides, by the way, are attached to under handouts, so you can download them. But I put this here just so that you have the language. If you aren't able to download this for any reason, you can wait, and we'll send it out in email as part of the recording of this webinar. So that's what's happening, and it happened, as Bruce mentioned earlier, because you all brought this up. And in really fast action from FHA, which we're really happy about that happened. So that's what went on with the FHA guidance. The other topic that I'm going to talk about is our meeting with David Berenbaum and some of the other staff from the Office of Housing Counseling about invoicing and billing. And, this is in the category of trying to figure out how to get the most money for housing counseling as possible. There were a lot of questions that, we convened a meeting of folks who are leaders in housing counseling and trying to figure out what are the issues that you're seeing and that you're dealing with. without getting into too much detail about what all of the individual things are, one thing really kind of rose to the top and became very clear was that folks were getting mixed messages from their point of contact and were unclear about certain things, and wanted more clarification. So this meeting went a long way to clarifying several things. One of the items was, if you are confused about what is going on and what's being told to you by your point of contact, you should certainly bring that to HUD's attention, specifically to Phyllis Ford. And I think most of you have her email address. We can include that in the email that we send out with the recording. But she really did want to hear from folks if you're having any kind of confusion or, you know, trouble with clarifying what it is that your point of contact is telling you. One of the things that came up over and over in answer to all of our questions was the 4 points rule of thumb. And I'm reading because I want to make sure I say these right. At number 1 has to be allowable under your grant agreement. At number 2 has to be allowable under 2 CFR 200, just appropriation rules. It has to be 3, it has to be reasonable, and it has to be 4, allocated properly. HUD did on April 15th, they did do a webinar on this allowable and unallowable costs, and those 4 principles they brought up over and over and over again. And they said that that was going to be recorded and posted. It is not posted yet, but I think that my colleague Ebony can pop into the chat box the link to the webinar section on the HUD website, HUD Exchange, so that when it does get posted, you can see it. But they answered a lot of questions about what does it mean for it to be allowable and reasonable, and especially the allocation rules about it being in your grant agreement and being under the specific rules. So there's that's basically what happened with our meeting with HUD. They were really attentive. They answered a lot of our questions. It's been really great to have such responsive people in the Office of Housing Counseling. And that is it for me. On to you, Bruce.
Excellent. And I will just point out that, well, it was probably 4 or 5 years ago that we had a marathon meeting with HUD, with the Office of Housing Counseling, and with a different set of issues where we're trying to get rid of the logic model and trying to improve the reporting and lots of those mechanical things back in the day with Sarah Jarek. And one of the outcomes was to create this special hotline with Phyllis Ford if you're having a problem with your POC. I think the big message here is that people were worried about being penalized because they made their POC angry or look bad. And the whole system is designed to positively take in our input and manage it well and professionally. And they've really thought this through pretty well. Phyllis is very excellent at this. So feel free to use it if you need it, if that's part of what your work stream. Okay, so I'm going to just jump on a few very quick things. So we've talked a bunch about the Black Homeownership Collaborative. There's many of you have expressed an interest in wanting to participate. There haven't been any kind of group meetings since we produced that 7-point plan, but they have asked that if groups are in support, that they show that we have broad support from across the country. As it gets rolled out, it's going to get rolled out. The 7-point plan is going to be rolled out probably jointly with the Secretary of HUD, Marcia Fudge, in June as a large national kind of announcement. And it'd be great if you want to have your organization listed with that. So I think Ellie sent out the 7-point plan and with a link to sign up. I know there were some glitches with the sign up. We continue to have to adjust them, but my understanding is it's now working smoothly. So please feel free to jump on, and we'll keep this open for another week or so that plenty of time for people to take a look at it and join if they want. We
I want to jump in real quick there, Bruce. That email with the second correction, the proper link, that'll go out right after the call.
Oh, okay, there you go. All right. You can tell who's on top of it here in the office. So and the other piece that a lot of you have been interested in, and we've been made lots of involvement with, has been with the down payment assistance program. That's very much targeted and really designed to be able to work, especially for Black and brown homeowners who are not only first-time home buyers, but first generation. And that bill, we now know that Maxine Waters will be sponsoring it. So one of the most powerful people in the House. She's deeply committed to this. It's not part of the infrastructure bill yet, but there's a lot of momentum for it. And so I think things are encouraging, but there's a lot of ground to cover. And as we know, the infrastructure bill has its challenges going forward, but again, lots of people pushing forward. So there'll be plenty more on that as we move forward, and we'll bring some of the people who helped design that program hopefully together to do a presentation soon enough. Also, through the Black Homeownership Collaborative, they've been doing a kind of a orientation or introduction to what the goals of the collaborative are and what we're trying to accomplish to various people of Congress and the administration. So the one with Secretary of HUD, Marcia Fudge, was Tuesday, and it was really impressive. So I felt like, you know, you do lots of meetings, don't need to really share them. This one I thought was really striking. And she took time in the meeting to say that, let's see if I get this right, they're going to close the race gap, and they're going to deal with it at FHA, which is major in terms of the ability of FHA to be even more effective, even though it's the largest source of mortgages currently, but plenty of issues about people being able to qualify. The GSEs, so that was important. She talked about down payment. She's talked about student loan debt, and the way that I think what this was about was the way FHA computes the student loan debt when they're evaluating somebody's back end ratio, and they could use the actual amount if they're on an income-based plan, and they don't necessarily do that. Credit scores, keeping people in their homes, racial equity throughout. She talked about how President Biden has deeply committed to this and has made this a charge of his administration. And they were very interested in the special purpose credit loans, which is a loan that can be targeted much more to underserved populations, to socially and economically disadvantaged populations. And she talked actually personally about how she lives in a Black neighborhood, and it's either in Cleveland or just outside of Cleveland. It's was her district, and there are 4 houses on her block that are valued under $75,000 and would not get a mortgage loan, and as an issue that they will figure things out on. So the other thing was the staff that we talked with afterwards, after she left, were really impressive as well and highly motivated to do things. And I'll just call out Lopa Kaluri, who said that, so she's working on FHA issues, which, you know, as we all know, is in some ways a difficult program, even though it's an effective one. And she basically said, we haven't been the best that we can be. And the charge is really to pay attention to the kinds of issues that we elevate. I brought up the cash buyer issue and first-time homebuyers not having a priority. Alana McCargo, who used to be at the Urban Institutes, now very high up at HUD, jumped all over that and said, you know, we want to know more about this. We're really looking at this. We know this is a major issue. We want to deal with it. So just sort of good news. I mean, there's a lot of enthusiasm. I think we've been very impressed with the energy that David Berenbaum has brought to the job, and he's moving pieces. And I think there's a more cooperative relationship we've got with the work we do in Congress and with HUD. And I think we're seeing progress that might potentially do some valuable things at FHA. This is good news, and wanted to share that with you. One other quick thing, which I think hasn't rolled out yet to the list, is we've talked about this before, and I know you're all deeply aware of it, that first-time homebuyers are disadvantaged in the marketplace today, and some of that is investors and cash buyers coming in. Some of it is that there's sets of rules that are favored by maybe real estate agents or sellers that disadvantage anybody coming in with a mortgage or with down payment assistance, or we've heard about things with FHA and VA loans, USDA loans, all of that. So we are going to ask you to send us examples of what you're seeing, and especially if you can give us actual documentation that we can use to both position the issue and also present to HUD. And we're also is there going to be a call? We have working groups through the Americans for Financial Reform who are working on trying to figure out solutions on this. And if you feel like participating in that, we need really creative and experienced voices helping us figure this all out. So there'll be a call out for that shortly. And I think that's my list. So thank you very much. Looks like we've got a very strong turnout for today's call. So let's go over to the main topic. And we have with us, and it's about protecting generational wealth and keeping the family homestead in the in the family. And we have Lisa Sitkin from the National Housing Law Project, who has been a valuable and a source of both information and policy for us, and has done a number of really helpful trainings for us on these calls, and hopefully becoming a very familiar figure to you. And we also have Sarah Bowling Mancini from the National Consumer Law Project, and she is one of the leading voices in the advocacy around housing issues nationally, based in Atlanta. And both of them are tremendous resources and have helped with shaping the Homeowners Assistance Fund, lots of the initiatives that we work on nationally, and are helpful, especially in the kind of housing consumer voice, which in the homeownership field sometimes can get lost. So welcome, Lisa, welcome, Sarah, and we're very interested in what you have to say. And one other quick thing is that this will be recorded, so if there are other staff members that you would like to have see this, you'll be able to tap into it, because we hope that this will be a useful ongoing resource. So I'm going to jump off here. Hi, Sarah.
Great. Hi, Bruce, and thank you so much for that introduction. And thanks to Bruce and Ellie for inviting us to be with you today. It's great to be with you on this call. I know Lisa and I both have worked a lot with wonderful housing counselors over the years. And so we appreciate the chance to talk with you about these issues around preserving intergenerational wealth and keeping the family home. And we'll focus a lot on death of the borrower and dealing with a house after the borrower has died. But also, all of the things we're going to go over also apply after a divorce. So really, this is the question of successors in interest is the term that we use, people who become the owner of a home after a death or divorce, but are not the original borrower on the mortgage. And Lisa, is there anything you wanted to say as we kick it off before I jump in?
Nope, I think that covers it.
Great.
Happy to be here.
Excellent. So Ellie, we can go to the next slide. Thanks. Here's an overview of where we're going. We have a lot. This is ambitious, but we're going to try to keep us on track and also save time for questions. Feel free to type in questions at any time. We're going to stop about halfway through and take any questions at that point. And also Ellie can interrupt us if there's something we need to take in at a given moment, and then we'll have more time for questions at the end. But what we're going to do is first talk about how we deal with this when someone comes into the office and you're trying to figure out what's going on and what the options are. So the initial investigation, we're going to spend just a moment about the related issue of an absent co-borrower. So maybe you have a client for housing counseling who is a borrower on the loan, but there's someone else who is also a borrower who is either deceased or there's been a divorce or family separation. So we'll just touch on that briefly. Then we'll talk about what is an assumption and can a non-borrower assume the loan and become a borrower. We'll talk about special rules for loan modifications for successors from Fannie Mae, Freddie Mac, and FHA. Then we'll talk about the CFPB rule or the RESPA rule about successors. And very briefly at the end, we'll talk about bankruptcy as a backup option and a word about reverse mortgages. And I should say right off the top, reverse mortgages are different. So everything we're going to say for the bulk of the presentation applies to forward mortgages, but keep in mind that reverse mortgages are special, and we'll just touch on that at the end. Okay, next slide. So the first thing you're going to be thinking about, ideally, when you realize that you have a client who is trying to save a home, and it seems that they might not be the original borrower on the loan, is just to start with that initial question: is this person a borrower on the loan? And sometimes people don't really know for sure, especially when there's a spouse situation. You may have two spouses who were married the whole time, they bought the house together, and sometimes after one spouse has died, the other spouse might not be fully certain whether or not he or she is one of the original borrowers. And she might say, I was at the closing, I signed the papers. And so the important thing to be aware of here is that anytime you're talking about a mortgage, you're really talking about two key documents: the promissory note and the security instrument. Those are the two pieces of paper that really make up a mortgage loan. The promissory note is the obligation to pay and says, I promise to pay this debt. And then the security instrument is what you would usually call the mortgage or deed of trust, or in Georgia, it's a security deed. That is the document that gives the lender the right to foreclose if you don't pay. And that security instrument is the document that gets recorded in the deed records. And oftentimes, if there were two spouses that were going to be on title to the home together, they both would have had to sign the security instrument because they both would have been on the deed, giving them ownership of the house. So then they both have to grant their interest to the lender to give the lender the right to foreclose. So it's possible, and it's actually pretty common, that you might have a married couple who both sign that security instrument, but only one of them signed the promissory note. So when we say, is the client a borrower on the loan, what we really mean is, are they a borrower on the note, the promissory note? Because that's what determines who has the personal obligation to pay. And so, as I said, sometimes people don't know for sure. And a few good ways to figure this out is, of course, if they happen to have their original set of closing documents in the folder or envelope tucked away somewhere, you can find the promissory note. But if they don't have that, the note itself is not recorded in the deed records. So one way to figure this out is usually the name that's on the mortgage statement is the borrower. And so if it only has one person's name, there may have only been one borrower on the note. And if both names are on the statement, usually that means they were both on the note. So that's one rule of thumb. And then the other is just asking the mortgage servicer, or if the client tells you they're refusing to talk to me, they're saying I'm not a borrower, and she might be confused and say, I thought I was a borrower. But if they're refusing to talk to the person, it's probably because they're not a borrower on the note. But it's just good to understand that this can, it's important to verify that. All right, next slide, please. The next question after you think about whether this is a borrower or a non-borrower is this person an owner of the house? Do they have an ownership interest? And so there's a few ways that could happen. We are going to talk mostly about death and inheritance, but keep in mind too that even after a divorce, the person that's coming into your office seeking housing counseling might have been awarded the home through a divorce decree or a separation agreement, or just a deed from the other co-owner or former spouse. And then if there is a death, you're looking to ask, was there a will? If there was not a will, did this person inherit an interest in the home through intestate law, the operation, the automatic background rules that apply if there was no will. And then sometimes you have a situation where the person that lives in the home and wants to try to save their home actually does not have an ownership interest yet. And those are the hardest cases, of course. But if you have a spouse where they're in the midst of a divorce or separation, but there's no divorce decree, and the client that needs help is not actually on title yet, and hasn't yet gone through that divorce, it can be very difficult. Or if you have partners that were never married and one person is now gone out of the picture but has refused to sign a quitclaim deed to the remaining partner, that's also can be very challenging. But really, those are the first two questions you're asking. Is this a borrower, and is this an owner of the house? Okay, next slide. And when you're thinking about whether this person is the owner, one question that comes up is, do we need to file probate? Does this person who's sitting in my office wanting to try to save this home, do they need a probate petition? And the answer is, it depends. And sometimes lenders or servicers will say you have to go file probate. And that seems to be kind of a gut reaction, an immediate assumption that, oh yes, if there's been a death, you absolutely have to file probate. And that's not always true. There are a few circumstances in which the heir that has inherited the house might not need to file probate. So we just wanted to raise this so you'll be aware that sometimes probate is not necessary. The biggest example of this is, if you look at the original deed to the house, do you have two people who were both on the deed from the beginning with right of survivorship? And the right of survivorship is something where the deed actually says granted to Jane Smith and John Doe with right of survivorship. And if it says that in the deed, then when one person dies, their interest automatically goes over to the other person. Automatically, there is no need to file probate if they were both on the deed with right of survivorship, because John Doe, if he dies, his interest does not even pass to his estate. It automatically passes to that other person if the deed says with right of survivorship. And those words would actually be in the deed, the warranty deed or quitclaim deed when they bought the house. The other possibility is some states have something called tenancy by the entireties. And that is a law that says if a deed is granted to a married couple, we assume that it is with right of survivorship. So in states that have tenancy by the entireties, the deed could just say from seller to John and Jane, husband and wife. And if it says that, and you're in a state that has tenancy by the entireties, then same situation where it's automatically going to transfer when one of them dies, it will go fully to the other person. So if you're not sure, if you're in a state that has tenancy by the entireties, you can check with an attorney in your state, or you can even try Googling your state and tenancy by the entireties. I'll tell you that Georgia does not have it. Lisa, do you have it in California?
Well, we have community property that.
Okay, so then there's also community property.
Yeah. But I'll also say, I mean, in California, the thing to know is there are cases here, I know in California, where the words right of survivorship may not show up in the deed, and we call it a joint tenancy as opposed to a tenancy in common. There are just a lot of jumbled words. So I would say that, if you're in any doubt, that it really would be useful to consult an attorney or try to dig into what that language means in your state, because it's going to be an important difference for somebody whether they have to actually go through probate or whether something has happened automatically, which makes it all a lot easier. Yes. Can I add one thing to this list also, and then
sure.
Get back to you? One other circumstance where the person should not need to go to probate is if they have, and this is pretty common in California, and there, it varies in different states, but is when somebody has what's called a living trust, and the house has been put into that trust, and the person who is the survivor, it may be a spouse, it may be another person, is now the trustee and beneficiary of that trust. That also should mean that this can pass pretty much with just recording a document rather than having to go through the probate court. So that's something to keep an eye out for too. And another place where the servicers will usually get it wrong. So you have to correct them.
I'm really glad you mentioned that. And I think that is more common in California than in a lot of other places. I haven't seen it very much in Georgia, but that's a really good thing to mention. And so the point being that if people have to file probate, it can be expensive, it's complicated, they may need a lawyer. Sometimes there's not free assistance with that. There may be a probate assistance center or whatever, but you don't want to have the client go through probate if they don't really need to. And the final other one I'll mention is, there's something called an affidavit of heirship, that if a person dies without a will, and if they've been dead for more than 3 years at the point in time where you're having to deal with it, just recording an affidavit in the deed record that says this person died without a will and these were the heirs, that may be enough. In Georgia, it depends on your title standards. So the title attorneys are the ones that decide these things. But it may be enough just to have an affidavit, and that's really cheap and easy to do. So I like Lisa's point of, if you're unsure, contact an attorney. Hopefully people have relationships with legal services attorneys in your state, and if you're ever trying to find one, feel free to reach out to either of us. We can try to put you in touch with legal services attorneys in your area. And then keep in mind that there's also a question of what is the client's goal here, and are there other heirs? So if there was a death and there was no will, in most states, typically the spouse inherits an interest, but also the children. And there could be many heirs. So ideally, if the person is trying to save the home and deal with the mortgage company, the cleanest way is if they can become the sole owner. It can be possible, even if they're not the sole owner, even if there are other co-owners. But ideally, you've got a situation where you can get this client who wants to save the home and pay the mortgage to be the sole owner. And if all the other heirs are willing to cooperate, they can convey their interest, or they can agree to do it that way through the probate filing. Okay, next slide, please. I did want to say a word about absent co-borrowers, which is really not the main issue that we're talking about today, but it often comes up in the similar situations where you have someone in your office or that you're counseling over the phone or whatever in this pandemic age, who is trying to get a loan modification and they're having trouble, and there's been either a death or a divorce. Sometimes the person you're counseling actually is an original borrower, but there was also a co-borrower, their spouse or other, co-borrower. And so this can pose problems. And we just wanted to mention the fact that servicers may get this wrong. And sometimes the servicer will say, you can't get a loan modification without that other person also providing proof of their income and signing all of the documents. And oftentimes when they say that, that's not correct. And so there are good rules in this situation, especially Fannie Mae and Freddie Mac have made it pretty clear that if there's been a death or a divorce, you can disregard the absent co-borrower and go forward with just the one who's occupying the home. The FHA rules are not as clear, and we have been working on that issue. NCLC has been pushing FHA to make the rules clearer with absent co-borrowers, and unfortunately in their latest handbook issuance for FHA, they did not fix it in the way we had asked. So please bring those problems forward to NHRC and to NCLC if you're seeing them, because we need to keep pushing FHA. But the short version is you can often help these people, even with FHA loans. It just takes a little more advocacy. Okay, so next slide. One thing we wanted to mention, both for absent co-borrowers and for these non-borrowers that we're mostly talking about, is you're always looking at what rules apply to this loan. And I'm sure most of you are familiar with this already, is that you've got to figure out, are there some investor rules that apply to this loan? This is one of the upfront things that you do in the investigation. It's really important to know, is it an FHA insured loan or VA or USDA? Or is it owned by Fannie Mae or Freddie Mac? And of course, we provided the links here to the loan lookup website, since most borrowers have no idea if their loan is owned by Fannie or Freddie. But if you go to the loan lookup, you can search and find whether or not this is a Fannie or Freddie loan, because then you can cite the applicable rules that govern this loan. And those rules are very important when you're dealing with non-borrowers and heirs that have become the owner of a home. I will say when you're doing the loan lookup and you've got a successor in interest who's not a borrower, if they ask for the last four of the social, remember that's the borrower. You're needing to have the borrower's last four of their social security in order to look up the loan, because that's what Fannie and Freddie would have in their system. So just wanted to mention this. Okay. So if we go to the next slide, the big question that we want to take on, and I'm going to walk through a few of these issues, and then Lisa is going to talk about the simultaneous loan modification and assumption rules that are really the most helpful in this area. But I wanted to say a little bit about what does it mean to assume a loan, and this big question of, can this person who is sitting across the table from you and asking for help, can they assume the loan? Can they become a borrower on the loan? And then in addition to can they, the other question is, do they want to become a borrower? Because it's important to know that the other option is to just stay and keep paying. Someone can inherit a home and keep paying the mortgage. And they don't, if they do that, they're not becoming personally liable on the mortgage. It's not their debt, but they have the right to just stay there and keep making the payments. And if they do that, the mortgage company cannot foreclose if they are one of these special types of successor in interest that we're going to talk about. They've inherited the home or been awarded in a divorce or one of these family transfers. They have the right to stay and pay. And if they do that, they're not taking on the debt personally. So it's not going to be reported on their credit for good or for bad. And if there's ultimately a foreclosure, they're not on the hook for any deficiency, any shortfall. So in some ways, it can be good for a person to not assume the loan and just keep paying the loan. And because of the RESPA rule that Lisa's going to talk about, they should be able to get information about the mortgage and communicate with the mortgage company, even if they do not assume the loan. And that's the most important thing about the RESPA rule, is it gives these people who have become the owner of a home the right to get the information about the mortgage that they're paying. So just keep in mind that if they don't want to assume the loan, they can keep making the payments. They won't be personally liable. However, if they don't pay, the mortgage company will be able to foreclose because the person that inherited the home took that ownership interest subject to the mortgage. So even though they're not personally obligated on the debt, the lender has that security interest in the home that was higher priority than my ownership that I obtained when someone died. So if the mortgage doesn't get paid, they will have the right to foreclose, but you can just keep making the payments. Next slide, please. So the question is, can they assume the mortgage and actually become the borrower? And that's part of determining whether they want to or not. So what is an assumption? An assumption is a legal agreement in which a new person becomes responsible for the loan and it becomes their debt. And it gives that person all the rights of a borrower and all of the responsibilities of a borrower. It does not relieve the original borrower of their obligation. So you've got to separate two things, an assumption and a release. And the kind of assumption that I'm going to be talking about mostly today is where a new person steps in and becomes obligated on the loan, but it does not necessarily mean that the original borrower gets released. And typically, in a death situation, you don't care about releasing the original borrower because they have passed away. If you have a divorce, this is a lot trickier. And sometimes in a divorce situation, the other spouse wants to be released. And then you've got to deal with that question, which is a separate question. But I just wanted to point out that an assumption is when the new person becomes liable, and it doesn't typically mean that the original borrower is released. And Lisa, I think you had an example that you wanted to talk about on this issue involving a Freddie Mac loan.
Yeah, so I had a client a while back who had a loan. I think it was actually with Wells Fargo, but it was a Freddie Mac loan. And her situation was that she had gone through a divorce, and in the divorce agreement, the final agreement that they entered into, she had committed to basically, getting her ex-husband off the loan by some date, a number of years or something. And the problem she was facing is that at the time that she was obligated to do that, the house was underwater. So she wasn't going to be able to just refinance. She also had some, financial hardships of her own and really needed a modification. So what she wanted to do was modify the loan and get his name off of it. And what's important to understand about those situations is that there's no requirement that the lender allow that. But I was able to dig in with Freddie Mac and, press the servicer, and ultimately we did manage to get him off the loan so that she could, comply with that obligation from her divorce judgment. But that's probably a rare situation, and it could easily have gone the other way. So a lot of times people assume when there's been a divorce or, a split of partners, whatever it may have been, who co-owned a home, that it's sort of an easy matter to just, remove someone from the loan. But you can imagine from the lender's point of view, they want to keep everyone they can obligated on the loan, right? They want to get their money. So that is something that I find that homeowners often assume will be easier than it is. And it's just important to know that while it may be possible in the rare situation, it's usually not going to be, an easy road for them.
I totally agree. Yeah, Ellie?
Yeah, I'm going to jump in quick. There's a couple of questions that I think are pertinent to answer at this juncture. One of them is just to clarify, if an heir inherits the home and does not want to assume the loan, they can just continue to pay the mortgage that was already in place?
Yes.
Okay. And can a non-borrower, after assuming the debt, refinance the loan?
Yes. And that actually is a great thing to add on to what Lisa was just saying about the divorce situation. So often the ex that's leaving the house wants to be released, but the ex that is becoming, getting involved now doesn't have enough credit history to necessarily get that person released. So what I think can work well is getting that the spouse that's remaining in the home to be able to assume the loan that is already there and start making payments. And then after 6 to 12 months of on-time payments, it would be much easier for that person to then refinance, and the refinance would release the other spouse from liability, assuming that the one who's still there is doing that refinance on her own. So yes, it is absolutely possible to do it one step at a time. Do an assumption first and then later do a refinance.
Okay, one more question. You may be addressing this later, but I'll ask it now. Mortgage companies will not share mortgage information if your name is not on the promissory note. Is there a workaround?
Yes, and we are going to get to that later. So I think we should hold that one. Yeah, because that's what the RESPA rule is all about. And the reason the RESPA rule was passed, and it only took effect in 2018, so it's still really new. The reason it was enacted by the CFPB is that there were huge problems in this. And mortgage companies would say, we can't talk to you, we won't talk to you. And the advocates, the counselors and legal services attorneys were saying, yes, you can talk to them. This is not a random person. This is the heir who owns the home. And really, there was nothing that legally prevented them from talking with these heirs, but now they are required to talk to them because of the RESPA rule. So we'll get to that in a few. Okay, so let's go to the next slide. And thanks for those questions, Ellie. I think that was good to take some of those now. So a little bit more about what is an assumption and how does it work. The starting point, and this is always the thing that I harp on, is that the client, the heir who inherited the home, gets to decide whether or not they want to assume the mortgage, not the mortgage company. The mortgage company cannot legally prohibit this heir who inherited the house from assuming the mortgage. However, unfortunately, there are a lot of misunderstandings around these issues, and lenders and servicers will often say, you cannot assume, you're not qualified to assume, all of these things. So we know those problems will come up. And I think they come up because these issues don't happen often enough for there to be good training and good systems in place. So unfortunately, it happens rarely enough that a lot of the line people at the servicers just don't know what they're really supposed to be doing. And it's gotten a little better over time, but we know that you will still encounter problems. But I just want to explain why it is that the heir that is now the owner gets to decide whether or not to assume the mortgage. First of all, what we're talking about here is what I call a non-qualifying assumption. And you might find some lenders and servicers that use that term. And there's something else that would be a qualifying assumption. So I think it's fair to describe them as two different buckets. The non-qualifying assumption is a situation where you have a family transfer, that we're going to talk about these types of transfers, and that person has the right to keep paying the mortgage. They also have the right to assume, but they cannot necessarily get the original borrower released unless they qualify. So the question of qualifying is, if you want to get the original borrower released, then you, the new person, have to show credit worthiness and credit score or whatever, so that the lender will give up that original borrower. But what we're talking about here, just as a starting point, is getting that new person to be a borrower before you worry about releasing the other person. And that should be considered as a non-qualifying assumption. Okay, but keep in mind that they don't have to assume the loan to make the payments. They can just keep making the payments. All right, next slide, please. I'm going to walk through a little bit of legal background here, and I realize that you don't need to understand the law in great detail, but just to kind of give you a little bit of this background to make you more comfortable with understanding the issues, and then understanding too that you can always reach out to a legal services attorney or one of us if there are questions and the servicer is pushing back and you're not sure if what they're telling you is correct. So, background contract law is that contracts are freely assumable unless one of three things applies. The first one is a contract for personal services. So this would be like if you hire Vincent van Gogh to paint a painting for you, or the example I like to use is if you hire Taylor Swift to do your 4th of July concert, I can't show up and be like, hey, I'm gonna perform instead of Taylor, even though I'm sure I would do a great job, but that would be a contract for personal services. So those are not freely assumable. And if it's against public policy, something would not be freely assumable, but that doesn't apply to a mortgage where you're just paying money. The last thing is restriction in the contract. Is there a restriction in the contract that says that it's not freely assumable? And we'll go to the next slide here. And I will tell you that there is a restriction in the contract. It's called a due on sale clause. And almost every mortgage in the US has one. And it really should be called a due on transfer clause, but you're often referred to as a due on sale clause. This is the clause in the mortgage that says that if the property gets transferred or sold, the lender has the right to call the mortgage due and say, you got to pay me back this whole mortgage or else I'm going to foreclose. So this is the way that creditors control who is the borrower that they're dealing with. And you can see why lenders do this, right? They want to approve one person as the borrower or whatever, original borrowers, and they don't want that person to be able to sell their house to Joe Schmo down the street and have Joe take over making the payments. So the due on sale clause is what allows the lender to say, if you transfer away the house, we don't have to allow that new person to step in. We can call the loan due, and then the whole balance is due, and if you don't pay the whole balance, we can foreclose. So if there's no due on sale clause in the mortgage, they would not have the right to do that. And you should check the mortgage. If the borrower has it, you can look for it, but almost every mortgage in the country has one. It's very rare nowadays. Before like 1980, it was more of a patchwork, but now they're pretty much always there. Next slide, please. And I've given you in the slides here an example of what the wording says. So this is the due on sale clause. If all or any part of the property is sold or transferred, without the lender's prior written consent, lender may require immediate payment in full. And so when they require the immediate payment in full, they've accelerated the loan. And then when it's not paid off, then they have the right to foreclose. So this is the language of the due on sale clause. We'll go to the next slide. And the bottom line is due on sale clauses are enforceable in the United States. And this is the federal law, St Germain. The St Germain Act says that due on sale clauses are enforceable, except for certain circumstances. So here's the main language that says, notwithstanding anything else, a lender may enter into or enforce a due on sale clause. And then if we go to the next slide, I will tell you that although generally lenders are allowed to use and enforce these clauses, there are some exceptions. the lender is not allowed to enforce a due on sale clause after these kinds of transfers. And there is a list here, and I'm going to decode them for you a little bit. But the bottom line is that after these kinds of what we call intra-family transfers, the lender may not enforce the due on sale clause. And this is federal law. And so what kinds of transfers? These are, the first two are both related to death. The first one is any transfer upon death to a joint tenant or tenant by the entireties. So this is both people are on the deed, and it's with right of survivorship, or the other one we talked about under California law, you know, where automatically upon death it transfers. That is one kind of protected one. The second one is any transfer to a relative resulting from the death of a borrower. So that would be there's a will or there's not a will, but somebody died. And when they die, their interest passes to an heir. That is one of these special GARN exempt transfers that under the Garn-St. Germain Act, that heir is allowed to come on and start making the payments, and the lender cannot foreclose on the basis of that transfer. And the other ones are a transfer to a spouse or child of the borrower. That can be a deed, just a quitclaim deed saying, I'm giving this house to my spouse or child. And then, of course, any transfer through a divorce decree or separation agreement. And there is another one, which is the inter vivos trust that Lisa mentioned before, the living trust. That's also a special GARN exempt transfer. If you put the house in an estate planning trust, that's okay. And the loan cannot be called due and payable. Next slide, please. And so the upshot of Garn-St. Germain is that these loans, the heir or person that receives a house through a divorce can assume the loan because that due on sale clause that would have been used to restrict them is not enforceable under the Garn-St. Germain Act after these special kinds of family transfers. Now, the lenders, as I said, will get this wrong, and the lender will tell you this is not an assumable mortgage. They will tell you that this is not an assumable mortgage. What they mean by that is this mortgage has a due on sale clause in it. And what you say to them is, I know there's a due on sale clause, and under the Garn-St. Germain Act, you may not exercise that due on sale clause because this is a family transfer and it's an exempt transfer under the Garn-St. Germain Act. So just be aware that the lender will tell you it's not assumable. What they mean by that is there is a due on sale clause in the loan, and it doesn't matter that there's a due on sale clause because it's a special type of intra-family transfer. Okay.
Can I just add one thing, which is that I know we're talking about assumptions and how this all fits together, but for the same reason that Sarah's talking about, that they can't enforce those due on sale clause, even somebody who's not assuming the loan, that's why they can just continue to pay it even though they're a new owner, right? Because they inherited it or they got it in the divorce. That is a thing that the servicer may get wrong also, especially if there's been some delinquency. Even if the person's going to reinstate and keep paying, they may, push back on that. So it's important to understand, even, they can assume it and the borrower has the right to do, or the new owner has the right to do that, but they can also just keep paying for this same reason. This is the kind of legal framework behind that.
Exactly right. And keep in mind that when there's a due on sale clause, like what if you have a transfer that is an arm's length thing that's not a family member or not one of these strict categories, the due on sale clause would give the lender the right to foreclose, but often they don't. And just be aware of that too, that, sometimes people will talk about deeding the home to someone else and, oh, there's a due on sale clause, so they might foreclose. Typically, if the mortgage is getting paid, they're not going to foreclose. Because they don't really notice all these transfers, but there's always a risk that if you have a transfer that is not one of these special categories, the lender could foreclose on that basis. But Lisa's exactly right. This is what allows that heir to just keep making the payments if they want to. Okay, next slide, please. And after this, we'll pause again and see if there's any more questions we should take. Then this brings up the question of how does someone assume the loan? And what we say is that there are no necessary formal words. It can be done through a number of ways. If someone signs a loan modification agreement, that could be an assumption. Any document that you can point to that says, I hereby promise to pay this debt could be good enough. Simply making the payments is not enough. Because as we said before, you're allowed to make the payments without taking on that legal obligation. But if you sign a document that says, I promise to pay this debt, that can be enough. The lender will not recognize you. It will not go smoothly. You know, the best way to do it is to, as Lisa's about to describe, to go through this simultaneous loan modification and assumption in which the lender knows that you are assuming and they've said yes. But, you know, just keep in mind that if you have to, you would work with an attorney on this issue because it's going to still require some heartache to enforce it. But there are a number of ways that a person can assume a loan. Okay. Ellie, are there any other questions we should take at this point?
Yeah, there's a bunch of questions I'm gonna go through with you all right now. So, if a person dies and leaves property in a will, is it better to also have a trust?
Lisa, what do you think about this?
So it's really going to depend on what state you're in, because the way that, you know, the transfer of property upon a death looks really different depending on the state law. I mean, I can speak for California that in general, my advice as an attorney, and I'm not an estate planning attorney, but just very generally, is that things are going to go much smoother if there is a trust. Usually, if there's a trust, there's a will that's called a spillover will that's just sort of for any extra things that didn't make it into the trust for some reason, but the trust is the main vehicle. And the reason for that is that with a will here in California, you need to go to probate court. Even though it says this is who the heir is and everything, you actually still have to go get the court to give their, you know, stamp of approval. And that's costly and takes time and usually requires an attorney. So for California, and I'm not trying to speak for other states, you know, I would favor the living trust and ideally working with an estate planning professional to help with that.
And I just want to add on to that, that the other trusts are not as prevalent in all places, and it does require a lawyer, I think, to set one up correctly. But the other similar thing is that deed with right of survivorship. So if, for instance, you have, and some places have something called a something on death, like a conveyance on death. But anyway, in all states, there is this instrument, which is a deed from me to me and my heir or whoever with right of survivorship. And if you have that, you also don't have to go through probate. So anyway, these are just ways to not have to file probate, because probate is costly and time consuming.
Okay.
And I'll just put in a plug, because it was a great question to bring that up, because there's lots behind it, that when you're working with borrowers, not because somebody has died and they're coming in sort of in a distressed situation, but when it's earlier, you can really help them be proactive. A lot of the problems that all of us deal with in these situations are because there hasn't been sort of advanced planning and laying it out and trying to create an easier situation for the heirs. So that's really something that you can benefit your clients immensely by steering them toward doing some estate planning.
Great. What about if the borrower dies and was the only one on the note, but then added someone else on the title years prior to death? The deed was written as tenants with right of survivorship. Does the successor and interest apply in this case?
Yes, so it does. And that and the things that Lisa is going to discuss next will be helpful for additional kind of to smooth the way. But yes, that is a situation where the person was added to title, but they were not an original borrower. So they are what we call a successor in interest. And they should be able to, after the borrower's death, they're then going to become the sole owner of the house because of that deed with right of survivorship, but they're still not the borrower. So then they're going to either want to assume the loan or stay and keep paying and use the RESPA rules. But yeah, that's exactly on point for this situation.
Okay, somebody's asking for contact information for both of you, and I want to let everybody know I did put emails for both Lisa and Sarah into the chat box.
Great. And do feel free to reach out. Yep.
Okay.
So should we keep going or?
Oh, yeah, yep. If a husband and wife established a life estate, leaving home to 2 children, the husband is now deceased, and the wife is wanting to change who the house is left to, can she do that?
Ooh, this is a tricky one. So if it's a life estate, oh gosh, this is a real property law. This is a deed that gives them a life estate, right, Lisa?
Yeah, they need to consult with an attorney because
Yeah.
it'll depend on some very specific things about how that document was written. Some, depending on kind of what type of document and the wording, it may bind the surviving spouse, but it may leave her free to make changes, and somebody would have to, you know, a lawyer would have to look at that document to make that call.
Okay, so this person has a client that has an FHA mortgage and his spouse died. The servicer is insisting that he remove the deceased spouse from the deed. They were tenants by the entirety and both borrowers. They are saying to secure title insurance for the new modification. Any suggestions?
This should not be happening, and I would escalate it with the FHA National Servicing Center, or go up the chain at the servicer. You know, if they had a right of survivorship deed, that person is no longer on title, and so it should not be any problem for them to get a loan modification on their own, get, you know, the title insurance. I just don't even think that should be an issue. But go ahead, Lisa, what were you going to say?
Yeah, I agree with all of that. I mean, you are going to have to escalate to FHA because the servicer's just not getting it, and you're going to just bang your head against the wall. But the other thing I'd say is it's possible that the servicer would be placated if something were recorded that just said this person has died. I have seen those recorded right after a death where it's not necessary really legally because the property is now just in the sole ownership of the survivor, you know, in the right of survivorship or tenancy by the entireties. But sometimes having that, if they're concerned about title and the, you know, the cleanliness of the title, let's say, sometimes having something that just reports that death actually can satisfy that request. So I would do both of those things, or consider doing both.
I think that's reasonable. And Ellie, I feel like maybe we should keep going if that's okay and save the rest.
Okay.
Unless there's...
Yep.
Okay, so let's go to the next slide. And then Lisa, I think you're picking up from here.
Yes. So we're going to talk about what are the rules that some of the key investors have for doing this, assuming a loan and getting a modification at the same time. And before we jump into it, I just want to say, you know, most of the time, the situations that we're all seeing are people who, let's say after a death or a divorce, are in financial distress, right? I mean, they have probably seen their income cut. There may have been a delinquency even before the death, but they're anticipating that they can't pay now because of the loss of the co-borrower, you know, the other owner. So that's why you're going to be looking at this idea of, you know, getting a modification and assuming the loan kind of as part of one whole transaction. But I want to distinguish again for people who can continue to pay, or who the loan got behind, but they can actually reinstate and then continue making payments. They shouldn't have to worry about any of this. They can assume or not assume as they prefer, but they shouldn't need to go through, you know, the steps that we're talking about here, because they don't need a modification, right? But as we know, most of the people we're talking to do need this, so that's why this matters. Okay, next slide. So for Fannie Mae loans, their rules reference exempt transactions. And what that means is that list that Sarah went through of transactions where federal law, the St Germain Act, says, yeah, you can enforce these due on sale clauses, but not in these exempt situations, those family transfers that are included in that law. So that's kind of the universe of transfers that the Fannie Mae rules cover. They require that when somebody has received the property through one of those covered transfers, the servicer has to communicate with the new owner. So those times when the servicer is saying, oh, you know, I mean, I think we've all had this happen. It's just so, it's both absurd and heartbreaking, is where they say, we need the signature of the borrower. and you're like, what are we going to do? Go to the cemetery? I mean, it's insanity. So this is clarifying, and servicers will get it wrong, but the Fannie Mae rules say you have to communicate with those people. And for somebody who is making a loan modification request to receive the property in one of those kinds of transfers, they have to be evaluated as if they were the borrower. So it should make no difference. So the servicer should be reviewing them for whatever waterfall of options, you know, short-term, long-term, all the different kinds of loan modifications. There should be no sort of restrictions on what they're considered for and what kind of options would be offered to them that would be different just because they have received the property, you know, from the original borrower. And then we've given you, you know, where in the Fannie Mae universe of rules you can find this information. And everyone, I would assume, is familiar with these lender letters, but also with the servicing guide itself that Fannie Mae has, and Freddie Mac has one too that we'll talk about in a moment. And those can be really important, you know, authorities to be able to point to or even send to the servicer saying, look, you're saying you can't talk to this person, but they inherited by right of survivorship. Let's say, you know, it was a husband and wife who had that kind of ownership. And, you know, here's what Fannie says. It's a Fannie loan. This is what you have to do. So that can be powerful in those situations, or you can escalate to Fannie, although I haven't found GSE escalations all that helpful, but still worth doing, and complain to the CFPB. Next slide. So for Freddie Mac, also kind of lines up with those St Germain types of transfers. And it's a little bit less specific maybe than the Fannie rules. So you have to kind of work out the logic of it, but it does provide for the simultaneous modification. And I think, I mean, we had this, it used to be HAMP or standard mod. Now it would be, you know, a COVID deferral or a flex mod, whatever it is that's available currently has to be provided to that person who's applying. And it has to be a simultaneous approval for the modification and assumption of the loan. Now, I'm not saying that everybody is required to be approved for a modification who's in this situation. You still have to, just like the borrower would, you still have to have, you know, the right amount of income or the right property, but, you know, all those things that go into, for example, a flex mod is very dependent often on property value. So it's just that that person essentially has to be treated like the borrower would have been treated if they were still around. And this is where you find this information in the Freddie guide. Next slide. So for FHA, as Sarah said, it's not always as easy, but they do have information in there, and it is something where you can probably get some help by escalating to the National Servicing Center if you need to. And the way that they lay it out is that if the St Germain exceptions apply, then you have to do this kind of simultaneous transaction, the assumption and the modification, but there are these conditions. So the person has to be occupying the home as their principal residence. I'm going to skip the second one and come back to it in a minute. They have to meet the financial criteria for loss mitigation. So that's just like, you know, you fill out your loan modification application and you actually have enough income to, you know, afford whatever the new modified payment will be. And they are willing to assume personal liability. So they're only going to get the modification if they also assume the loan. Those things go together. Now, I want to just come back to submits to a credit review, and Sarah may have something to say about this. I have always found this problematic because we know, having worked through these cases, that this doesn't mean a credit review like when you get an original loan. It's not like somebody has to, you know, have their credit report combed over and their score and everything, and they have to have like qualified for the loan before. I really see this as the same as meeting financial criteria for the loss mitigation assistance, like some kind of showing that you can qualify for that. But it can be a sticking point because it's a separate item on this list. And Sarah, I don't know if you've worked around that or if you have another take on it.
I do have something to say about this one because I agree with you that it's confusing and that this wording, this bullet point could make a servicer think that they have the right to deny someone who they deem not credit worthy. I think it means exactly what it says. You're willing to let them pull your credit. And I think the reasons they could pull your credit is to confirm that you're living in the home and maybe to confirm that you don't have another FHA loan, you know, but it doesn't mean qualify for the original terms because that would conflict with the next bullet that you pointed to, which says you qualify for the loan mod. So I have never had an FHA assumption and mod get blocked on this basis. I have more trouble with FHAs with absent co-borrowers as opposed to like non-borrowers. But I think that if a servicer gives you any trouble, the National Servicing Center will back you up that this person does not have to credit qualify for the original loan terms. They just have to, maybe they have to sign something and let you pull their credit, but whatever their credit is, they should be approved if they can qualify for the FHA loss mit.
Great, that's really helpful, thank you. Next slide. So as many of us who've been around in this field for a while know, there were some HAMP rules back when we had HAMP during the foreclosure crisis that actually were very helpful, that, you know, essentially said the same thing. Like if you inherit or are awarded sole title, you know, with a debt after a death or a divorce, that you should be treated like the original borrower. And that you should allow for the simultaneous assumption and modification under applicable law and investor guidelines. So that might mean, you know, the Fannie Mae guidelines, if those apply. And also that if there's a trial plan, the surviving homeowner remains eligible for a new one. So like ending that trial plan doesn't count against you for future kinds of assistance you might be able to get. Now, as you know, HAMP is no longer running, but we do think that the kinds of the rules like this and the basic idea of this person should be treated like the borrower still kind of constitute an industry standard that kind of came into effect and became the norm, right? This is sort of how it should be done, a best practice. So even if you're outside of the Fannie Mae, Freddie Mac, FHA, and, you know, VA and USDA don't have a lot of helpful guidance, but I think probably would ultimately treat them the same as those. But if you're in that private market where we're kind of swirling around with no clear rules or anything, I think we can look to this, and it's still worth, you know, advocating that this is kind of the way people should be treated, and even more so because of the rules we're going to talk about in a moment that the CFPB put in place. So we just wanted to kind of flag these, not because they're current rules, but because I think they're still should sort of form a basic understanding of how things should work. Next slide. So under the Real Estate Settlement Procedures Act, RESPA, which also is the act that applies, you know, when somebody's taking out a loan and buying the house and requires all kinds of forms and things at that front end, RESPA also has application to mortgage servicing, and in particular, the regulations that the Consumer Financial Protection Bureau has put in place since it came into being back in 2012, 13. And as Sarah said, pretty recently, as of April 2018, they've had these successor rules in place to protect people in these situations we're talking about. And those came out of precisely the kind of problems that, you know, Sarah and I and many of you were encountering already and reporting to the CFPB and other agencies. So let's go to the next slide and we'll talk about how they work. So the important thing to know is that there are kind of two pieces to the successor and interest rule under RESPA. First of all, it requires, and I think there may have been a question about this earlier, that the servicer provides an eligible non-borrower, so that's the person who's now an owner but not named on that loan, information about the loan so that they can make decisions. They shouldn't be put in the situation of having to try to modify the loan and assume it without knowing, what all of the amounts owing and the history of the loan and whether there were modifications before. There's a lot of information that goes into making decisions about what your strategy is going to be. And, servicers typically don't provide information to non-borrowers. They cite, privacy laws and things like that. But this says no, as long as a couple things happen, and we'll talk about what those are, that person needs to be given all the information about the loan, just like they were the borrower. And then also that the servicer has to treat that confirmed successor in interest, that's the language that's used in these rules, as a borrower if they apply for a loan modification. So again, we have this, pretty powerful authority to use, and you're going to have to use it because servicers still get this wrong, is what I hear. Not all of them, some have gotten it together. But they need to provide information, and they need to accept loan modification applications from people who are confirmed as successor in interest. So what does it mean to be a confirmed successor in interest? That's the next slide. That means somebody who's took an ownership in the property under one of these kind of transfers. And these track very closely with the Garn St Germain kinds of transfers, right?
They track exactly.
Yeah. They track exactly, right. So again, we're dealing with, these transfers to family members or in a divorce or in a living trust, all of those things. You can see them listed out here, and you will have the slides. So I'm not going to go through each one again, but that's kind of the universe of types of new owners, who got the property in one of these ways. They're covered by this rule. Next slide. So a confirmed successor in interest is somebody who's who's provided certain information to the servicer, and the servicer has confirmed their identity and their ownership interest in the property. And it's important that both of those things, right? So they may ask for some sort of identification. Usually where the issue comes up has to do with their ownership interest. And it's important to keep in mind that being a confirmed successor in interest, it doesn't require you to assume the loan or have assumed the loan. It's a separate kind of issue, right? Being a confirmed successor in interest just means you're entitled to get information about the loan, and you're entitled to, go through loss mitigation just like a borrower would have. Next slide. So there's a request for information. That's what RFI stands for, and it's that there's this new limited one, which is when somebody has, inherited or received a property through a divorce, they can make a written request to the servicer saying, I'm the successor in interest, and here's the name of the borrower, here's, the loan account if you have it, or other information to identify that loan. And then the servicer actually is legally required to respond to that. They're now called a potential successor in interest. They haven't been confirmed yet, but they have to respond by telling that person, here's what you need to provide to us so we can confirm your identity and your ownership interest. And here's the contact information for how you proceed and get further assistance. So this is kind of where the rubber hits the road, is this description of the documents that need to be provided. So it's not automatic. It's not that the person writes in and says, I'm a successor in interest, and then they're automatically one. It's this back and forth where the servicer then has to say, here's the documents you need. We know pretty well what usually those documents are going to be. There's no reason that the new owner or the heir, can't go ahead and provide those with this letter. You don't have to wait to do the two-step necessarily, but it's possible that there will be a little bit of back and forth. So, usually you're going to provide, for example, a death certificate or a divorce agreement or judgment, and you're going to provide, whatever else is sort of evidence that you are or are going to become the owner of that property. So in the case of the living trust that I've talked about a bit, it might be that trust document itself that would show that. Next slide. So they, as we said, have to actually communicate with the borrower, the servicer, once they've gotten that notice. And they have to go through, if they haven't gotten whatever documents they think they need to confirm the successor in interest status, determining those documents and providing that potential successor with the list of those documents. The idea being that this should, happen fairly quickly, right? And that there shouldn't be this long waiting period where the person has to kind of be in limbo, not knowing kind of what their next steps are. Next slide.
And I'll just add that this can also be done over the phone. So I think it was really good about the notice that they can send in writing, but also this rule requires the servicer even to do this over the phone as well, just to have these reasonable procedures in place.
And then once they get those documents, so it may have been, again, come with the initial letter, or, the person may send them in after they get the list from the servicer, they have to promptly determine, this person is a successor in interest, or, if there's something still missing, they need to let the person know that right away. And then they have to notify the person that they've confirmed their status. As I said, if any additional documents are needed, they let them know that. Or if they've determined for some reason that they're not a successor in interest, usually that's going to be these situations that we talked about before, where even though we know that under the law, somebody now is actually the owner, like they were, had a right of survivorship or something, the servicer may be saying, oh no, you have to show us something from probate court. So that's going to be the kind of thing where there will need to be an escalation within the servicer and possibly to the CFPB to work that out.
Next. I'm realizing that we're going to run short on time. I think these promptly and reasonably ones are probably not as important. If you want to kind of give the final nuggets about all this, and then we can see if there are more questions. Or
yeah, I'm seeing that on the clock too, and I want you to be able to talk about bankruptcy and reverse mortgage for a second. So I think you can read on the slide what promptly and reasonably mean, but the main key takeaway from this is that the servicer does have legal obligations, enforceable legal obligations, to actually deal with a person who says, hey, I'm the new owner of this property, to share with them the information that is needed in order to confirm them, and then to work with them on loss mitigation. That's what these rules effectively do. I will pass it on. So a couple slides forward. Yeah,
if you can go to the one that says bankruptcy, Ellie, and I'll just do the last two, and then we'll see if there are any real quick questions. And you can let us know if we can go over or if we need to stop right on time. So bankruptcy, just a very quick, oh, go ahead.
It's certainly fine to go over. People usually calendar, we will lose people at 2:30. So we don't want to go too far over.
That sounds good. We'll just go a few minutes past in case there are more questions. So the final thought about the RESPA rules that I just wanted to share is, once they are confirmed, as Lisa said, they are a borrower for purposes of RESPA and the TILA servicing rules. So they have the right to get periodic mortgage statements. They have the right to apply for a loan mod and have the dual tracking rules apply and all of the RESPA loss mitigation rule. And they also have the right to send qualified written requests, which is that a letter asking for information about the loan or disputing things that they think are being done wrong. So it's really important that they have those rights now under RESPA. So the word that we want to say about bankruptcy is, sometimes you have an heir who is trying to deal with this mortgage and they're hitting some roadblocks. Or let's say maybe it's not a Fannie, Freddie, or FHA loan. Maybe it's a private loan and the lender is telling them, we're not going to give you a loan mod because we just don't do loan mods for successors in interest. I think that would be pretty rare these days, but you might see that come up. The final resort is always the possibility of a bankruptcy, because if this person is an owner of the house now, that person now has the right to file a Chapter 13 bankruptcy, which is the payment plan bankruptcy, where they can use the bankruptcy plan to catch up the arrearage in the bankruptcy. They can do that even though they're not the original borrower on the loan. And even if they have not assumed the loan, they can still treat it as a claim in the bankruptcy based on the fact that they own this house and the house is secures this loan. So just keep in mind, bankruptcy is always a backup option. That's what we wanted to say about that. And then the next slide is about reverse mortgages. So just in 1 minute, just to let you know that everything we just said does not apply to reverse mortgages. So unfortunately, mostly doesn't apply. So with a reverse mortgage, the loan does become due and payable upon the death of the last surviving borrower. And generally, after the last borrower dies, the loan has to be paid off or else the lender will have the right to foreclose. However, the biggest exception is for non-borrowing spouses. So if you have a spouse that was not included on the reverse mortgage, that person has the right to stay in the home until they die, as long as they meet certain criteria that should be not too hard to meet, and they keep paying the taxes and insurance. And actually just last week, HUD issued a new rule about non-borrowing spouses that we were very excited about, that makes it a little easier. And if you have a reverse mortgage non-borrowing spouse and you have difficulties, please feel free to reach out. We're happy to help troubleshoot those cases. If it's not a spouse, but some other heir, like a child of the borrower or family member that's not a spouse, they do have to pay off the loan. They cannot keep living there because the loan becomes due and payable and the lender can foreclose. So other heirs have the right, they have to either sell the house or refinance or allow the lender to foreclose. And they have 6 months plus up to an additional 6 months to do that. And the good thing is, if the home is underwater, they can satisfy the reverse mortgage by paying 95% of the fair market value. So they can do a short sale or a short refinance. If you have heirs that want to keep the family home and they've got to pay off that HECM, that reverse mortgage, and let's say the house is worth $100,000 and the HECM balance is $150,000, they can pay $95,000 through a refinance and stay in the home. It's very hard to make that go smoothly. And if you're ever trying to help someone with that, please reach out because NCLC is very interested in that issue. It's part of intergenerational wealth transfer, especially for Black families, to try to keep these homes. So we're happy to help with those problems. And maybe we could just take a couple questions real quick, Ellie, and you tell us when we need to wrap.
I want to add just one point before we do that, which is that one of the slides we just went through gave some examples of problems we've seen with servicers dealing with successors. But at the very end, it also said successors and homeowner assistance fund. And as you guys know, there is this money coming in all around the country for borrowers who need help because of COVID. And it's important to understand that you know, we're trying to work on helping make sure the rules make it clear that successors absolutely have access to that, you know, if there's been a death or divorce during this period of time. But if you're seeing problems with the rules that your state comes up with for its HAF program, or once these get going, if you're having problems with getting successors help in those programs, please reach out to us as well, because that's something that we saw with hardest hit funds, and we want to try to avoid those pitfalls again.
Okay, so what I'll say is there are quite a few questions and there's no way we're going to get to all of them. Let's try to get to a few of them. People can listen to the recording even if they don't stay on to hear your answers. And anything we don't get to, I just want to let everybody know I'll email them to Sarah and Lisa and they can answer me and I'll get it out to you to let you know what the answer is. Okay, onward. Let's see. Is transferring the deed to an individual and removing yourself from the mortgage illegal?
It's not that it's illegal, it's that you can't do it. So you can't, if you're the borrower, transferring the deed to someone else does not remove you from the promissory note. And so now someone else owns the house, but you're still the borrower who has promised to pay this debt. And if it doesn't get paid, there will be a foreclosure, and it's still also possible the lender would come against you for any shortfall. So it's not illegal, but it doesn't have the effect that that person might be thinking.
And that is something that we see scammers do, get transferred the property and tell people that they're going to take care of everything, but then the people end up, having these defaults on something that's on their own credit report. So it's important to know that you can't sort of unilaterally remove yourself from the mortgage.
Okay, I'm not sure if either one of you know the answer to this, but I'll throw it out there. This person is curious how this could work if the home had, for example, a home-funded deed of trust on the property. Does the heir have to income qualify for home to remain living and or owning the home?
I don't know the home program very well, but I think it's a repair grant program. Is that right?
It can be repair, it can be down payment assistance, it can be that you bought the home because it was built with subsidized funds from home,
Yeah.
and there's a deed on it that limits your ability
There are
to.
a lot of, I'm sorry to cut you off. There are going to be a number of different programs. I mean, there are also, like in San Francisco, they have a home ownership program for low and moderate income borrowers that kind of caps sale prices and things like that to keep homes affordable for owners, or condos. They have a lot of those. That's all going to depend on the actual restrictions within the, four corners of whatever that loan says. So it's really going to depend on the particular program and what its rules are, to know, kind of what leeway somebody has to leave the property. Or
Okay. Does the Garden St. Germain exempt transfer apply to a non-family member who is on the deed?
If they're on the deed, I think it should, because that first one is a transfer upon a death to a joint tenant through a right of survivorship. So that is I think the best thing to do if you have a non-relative that you want to inherit the home, because the other one is just to a relative. But that first one is anything where it's a transfer by operation of law to a joint tenant, which means someone who's on the deed. So that can be fine.
I do want to add a warning, though, that we see people within and outside of families sort of casually, because it's easy to do, fill out joint tenancy deeds and add someone to take care of. It's kind of, cut rate estate planning in a way. There are other implications of that having to do with taxes and also just with control. Once you put somebody on that deed, you can't get them off yourself, right? You don't, then they have to agree to be taken off of the deed. So it's just not a step to be taken lightly, and really something we would suggest that the person get legal advice about doing, and not just, add them because it's the easiest way. It may be fine, but there are some pitfalls.
Great point.
Okay. Can the servicer require the surviving spouse to provide proof of marriage, such as a copy of a marriage certificate?
I think that could be, I'm not sure if this is about reverse mortgages or regular, but I think either way that could be reasonable. But it could be a marriage certificate. So if it's a reverse mortgage, I think they do usually request proof of the marriage. But it could be a marriage certificate or a death certificate that lists you as a spouse might be sufficient. So in general, I think this could come up. I haven't seen it really come up much with forward mortgages, but yeah, it could come up.
Okay. Somebody's just commenting that the HUD National Service Center isn't helpful.
Sometimes they are and sometimes they are not. I will just say, and I may regret this, if you try escalating with them and you get nowhere, if you email me, we can help. And Bruce and Ellie may be able to help with this too, but they're Matt Martin, and if it's a reverse mortgage, Casey Watson, the people up at the top can give something a little extra oomph. But I agree that sometimes just sending the sort of baseline escalation to them may not always work. I usually start with that, and then if you still have problems, there is another way to go higher. And same with Fannie and Freddie escalations too.
And would you suggest that CFPB complaint is a good alternative if that doesn't work?
I think a CFPB complaint can be helpful, and it's important to let the CFPB know about these problems. That's the main reason that I tell people to file CFPB complaints, is that they are looking for patterns. Quite often, it doesn't lead to a case getting resolved, but sometimes the servicers, when they get those complaints, they have to respond, and sometimes they do give it appropriate attention. So that's an option to explore.
Yeah, sometimes it actually ends up making the issue go to a different department, and that can help get things moving. But you definitely can't rely on CFPB complaints as the way to get resolutions. You kind of have to go on parallel tracks and try all the options.
Okay, let's go with this final question. I think you somewhat addressed this, but let's just kind of throw it out there. This person has an elderly client who bought her home with her daughter. She has a conventional loan. It's not GSE. Her daughter has abandoned the home and signed a quitclaim deed. The servicer is now requiring that her daughter sign the final modification agreement, but she refuses. Does the homeowner have any options?
So I think they said it's not Fannie or Freddie and not FHA.
Correct.
Yeah.
Correct. Didn't mention FHA, just said it's conventional, not GSE.
Yeah.
So I'm sorry, and she has a loan modification offer, but they're saying the daughter has to sign it?
Sign the permanent mod. And the daughter signed a quitclaim deed. So I think this is tough. I think it's worth escalating within the servicer, like go up the chain, talk to a supervisor, talk to the VP in charge of community affairs, any good contact at the servicer. But I can't think of anything that requires the servicer to honor a loan mod without that absent co-borrower, if it's not covered by any of these investor rules. The thing I would say is they definitely can accept the loan modification without that absent person. The absent person has relinquished her interest in the house, so the daughter gave up her interest in the house. So there's nothing that legally prohibits them from doing it, but they may not want to, they may not understand the law. I actually think partnering with a legal services attorney could be a good option on this, but it's a tricky.
Yeah, and the other thing to think about is, I don't know what the circumstances are of where the daughter is, but if it's the fact that she doesn't, you said, actually, I guess they are in contact and she's refusing to sign. Even that, the fact that there are circumstances that make it impossible for the person to get that co-borrower to sign, that plus the quitclaim deed, I think should be sufficient. And as Sarah says, it's certainly not against the law for the servicer to do that. They just kind of reflexively say no to everything. So I do think that if you can get legal services involved, that would be great. I'm happy to talk to someone about it too.
Great. Well, thank you both so much. And as I mentioned, any questions that didn't get answered today, we'll get them out to Sarah and to Lisa, and they are wonderfully responsive. So we should have that to you by sometime next week. Thank you both.
Thank you.
Thank you.
We'll send it off to you.
This was excellent. We really appreciate that. So just to say that we love what we do, and we really appreciate that we can offer things like this. Part of what helps us do this, and especially what helps us lobbying in Congress, is that people are members of NHRC, and you can get our membership application on our website. It's we've got a dues scale. You get a number of member benefits. The Savvy Online program, which is helpful we get deep discounts on that, and helpful for people with student loan issues. And we have the credit reports, which are much cheaper than what normal credit reports are for tri-merge credit reports. So all of that is great. I will point out that on the list that you see right there, Ebony Cartwright is our person who handles membership issues. So if you have questions about when your membership is due, what happened with your renewal, all those kinds of things, shoot her an email. You can always email me, but I'll just refer it to her to help us sort it out. So, and she's been doing a great job on that part. So thanks everybody for your great support, and we'll be in touch. Look for the list to see when the next calls are scheduled. Thanks a lot.